For our discussion of the Supreme Court, rather than spending most of our time reviewing its history, which I think the textbook does an excellent job with, I want to look at a handful of cases and have us discuss what we think of the Supreme Court's ruling, what we think of their logic, and how we might have ruled differently. The cases we're going to look at, ones that require the court to balance religious liberties with other essential functions of the state, are some of the trickiest ones the court has to consider. I don't think any of the cases that we're going to talk about this week have easy answers. Reynolds versus the United States was an early case in Utah previous to its statehood. Reynolds married two women at the same time and was arrested on charges of bigamy. Reynolds appealed to the Supreme Court, arguing that the prohibition against polygamy violated his religious freedom. Reynolds' lawyer argued that Reynolds' religion, Mormonism, required him to take more than one wife or face eternal damnation. The court ruled unanimously against Reynolds, upholding the prohibition on taking multiple spouses. But the court's argument relies on what seems to modern ears to be bizarre and possibly racist logic, saying that since polygamy had always been odious, that is repulsive, to North and Western Europe, and before Mormonism had been associated with Asia and Africa, that in and of itself showed that the Constitution could not have been meant to protect polygamy.
I don't really see why can't we go on as three?
The case of Wisconsin versus Yoder. The Amish believe that formal education should only continue through the 8th grade. But most states legally require students to continue going to school past that age. Amish families who refuse to continue sending their children to school after the 8th grade were therefore in violation of Wisconsin law and were prosecuted. The Amish argued that this was more than a tradition for them. It was part of their religion, and a law that compelled their children's attendance at school through the age of 16 violated their First Amendment religious freedoms. The court found in favor of Yoder and the other Amish families. In a dissenting opinion, Justice Douglas argued that the court wasn't paying enough attention to the future of the students in question. If they didn't go to school past 8th grade, they wouldn't be able to enter the world at a later point without being at a disadvantage.
Separation of church and state, no doubt they'll separate. But on a state, the state will be